All right, everybody. Welcome to our fourth chapter for Miami-Dade, where we talk about the topic of defenses to criminal culpability. Now, before we begin this chapter, let's make sure and really re-emphasize certain points regarding criminal law that I think are important for all of you to remember. Remember that when a person is being charged with having committed a crime, the state has the obligation of proving all of the elements of that crime. So the state has the obligation of proving the actus reus of the crime. The state has the burden of proving the mental state, the mens rea of the crime. And the state also has the burden of proving any attendant elements that are also found within that crime. Okay. And we had already discussed how attendant elements really were, or attendant circumstances really are those extra conditions that sometimes appear in a crime or in a criminal law that must also be met. And I believe the example that we discussed last class or a couple of classes ago was how in the case of burglary, old school burglary required that the crime be committed at night. And so that was an attendant circumstance. That's an additional element. That's not part of the actus reus. That's not part of the mens rea. That also must be proven by the state beyond a reasonable doubt in order for a jury to be able to return a guilty verdict. Now, aside from the elements, which we have already talked about, the actus reus, the mens rea, and then the attendant circumstances that must also be met as part of the crime, the state also has to prove that causation of the crime, the causation, which is the idea that the act and mental state of the defendant are what caused the death, or I shouldn't say the death, the harm that the criminal law is intended to prevent. So meaning the causation is the idea that it was the defendant's actions that caused whatever harm the law is intending to prevent. And additionally, the state must also prove beyond a reasonable doubt the fact that the actus reus and the mens rea were both present at the same time as when the crime took place. So for first-degree murder, which is historically defined as the intentional and planned killing of another person, the state has to prove that the defendant planned and intended to kill the person at the time they killed the person. It does no good if the person had initially committed a plan to kill somebody years ago, abandoned that plan, and subsequently killed the victim in a barroom fight that was not in any way, shape, or form connected to the planned out plans of the defendant from way before that. So there has to be what's called a concurrence of the actus reus and the mens rea with what happened, with the harm that was caused by the crime. So all of those criteria, all of those elements, the state has the burden of proving them. And by constitutional standards, the state must prove them beyond a reasonable doubt, which we've already previously discussed as meaning there cannot be any logical doubt whatsoever that the defendant is the person who committed those actions, that the defendant is the one who committed the crime, the defendant is guilty. If there is one logical doubt, the jury must return a verdict of not guilty. However, separate from the state having to prove all of the elements of the crime, the defense is allowed to raise what are called defenses. Now, defenses is a very broad category. Okay, we can really roughly divide defenses into four categories. The first one is that nobody committed the crime. The second one is that the defendant didn't commit the crime, it was somebody else. The third one is that the defendant committed the crime but is not criminally responsible. And the fourth one is that the defendant committed the crime but for some reason is justified in having committed the crime. Now, if the defense's strategy is to say, hey, listen, no crime was committed, that basically means that they're arguing that the state has failed or is going to fail being able to prove their elements that anybody committed a crime. Cool. The defense doesn't have to do anything in that circumstance. They can just, at the end of the trial, tell the jury, hey, jury, the state failed. The state did not meet its burden of proving the case beyond a reasonable doubt. If the defense says, hey, you've got the wrong guy, the strategy the defense is taking is that somebody else committed the crime. We're not denying that a crime was committed, but it wasn't our guy. It wasn't our guy. Now, if the state chooses, or the defense chooses to try and make the argument that for some reason the defendant is not responsible even though they did commit the crime, or that the law justifies the defendant's actions and therefore there are no, or there should be no criminal repercussions, no consequences for the actions that were done by the defendant. In those instances, now the defendant has to prove those defenses. Okay. Remember, the defense never really has to prove anything overall. In other words, the state always has to prove that the defendant committed the crime. There was an actus reus, there was a mens rea, there was a concurrence between the actus reus and the mens rea, any attendant circumstances that were attached to the crime that must be fulfilled for the crime to take place, and that the defendant's actions are what caused the perceived or the real harm that took place in the case, right? Whether it's a stolen object, a death, etc. However, if the defense says, listen, even if the defendant committed the crime, he's excused or she's excused, or we can't hold them responsible for some reason, those types of defenses, now the defense must prove. Why? Because the defense is trying to create a new argument. And the argument is, we may have done it, but if we did do it, here's why it's okay. It's either okay because we can't hold this person responsible for their actions, or it's okay because they are justified in doing what they did for whatever reason. And if the defense uses those arguments, now the defense has the burden of proving them. The question you have to ask yourself is, by what burden of proof does the defense have to prove them? And the burden of proof is the preponderance of the evidence. Now, if you remember, preponderance of the evidence is the burden of proof that takes place in a civil case, where the plaintiff, the party that starts a lawsuit, has the obligation, the burden of proving that what they're claiming happened, that was wronging them, did in fact happen by just a hair more of evidence compared to whatever the defense's story is. The best way of explaining this is, if at the end of a civil lawsuit, you believe the plaintiff's version of the story by a fraction more, just a fraction, then the defendant in that civil case is liable to the plaintiff. Meaning, they just have to convince you by a hair more, by a fraction more. It's 50% plus 1 mathematically, a hair over 50%. This is a significantly smaller burden of proof compared to beyond a reasonable doubt, which is the burden of proof that the state must overcome to prove a defendant's guilty. We've talked about how beyond a reasonable doubt means there cannot be any logical doubt on any of the elements of that criminal law for the defendant to be found guilty. For these types of defenses that the defendant is raising, we call these affirmative defenses. Why affirmative? Because they are affirming them, they are making them, they are positively making them, the defenses. For these affirmative defenses, the burden shifts only on these defenses for the defense to prove those defenses by the burden of preponderance of the evidence, by the burden of proof of preponderance of the evidence. So we can really categorize our defenses into, those four categories that I told you. But if the defense is claiming that somebody else is that the defendant is not criminally responsible, excuse me, or if the defendant is claiming that they were justified in what they did, and we'll get to what these terms mean. We call those two different categories of defenses affirmative defenses. The defense is positively raising them. The defense is actually going out of their way to make these defenses up. I'm not making them up because I'm not saying they're false, but they're asserting them. And because of the ones making that assertion, the burden shifts for those defenses only, for the defense to prove those defenses only. Understand, this doesn't eliminate the burden of proof that the state has to prove beyond a reasonable doubt that the defendant committed the crime. It just means that if the defendant raises one of these affirmative defenses, the defense has the burden of proving them by a preponderance of the evidence, by a fraction more than what the state can try to argue against, that the defendant's affirmative defense is true. So, what are some of these defenses? Affirmative defenses, right? Because remember, the defense does not require to create a defense at all. The state has the burden of proving anything, or everything rather, in terms of that the defendant committed the crime. If the defense says somebody else did it, all they've got to do is raise enough doubt, logical doubt, for the jury to say maybe it was somebody else. So the defense in that circumstance does not have to convince the jury by a preponderance of the evidence. These affirmative defenses only exist in situations where the defense is trying to affirm an argument, make an argument that they were excused in doing what they did, that they were justified in doing what they did. So let's talk about these affirmative defenses. Okay. But I do first want to give you the textbook definition of affirmative defense. The book defines affirmative defense as the introduction by the defense attorney of new factual allegations that, if true, constitute a complete or partial defense to the crime that was charged. Okay? So the way that the book defines an affirmative defense is the defense is making new facts. They're asserting new facts. And because of these new facts that they're asserting, they're claiming that the defendant is not responsible or is justified for having committed the crime, if they did commit the crime. Now, can the defense both deny that they committed the crime, but also say, in the event that the defendant did commit the crime, they were excused or justified? In other words, can they simultaneously deny the crime while also raising an affirmative defense? And the answer is yes. The defense can do both of those things. Okay? But if they try to raise an affirmative defense, as we've already said several times today, the defendant has to prove them by the burden of proof of preponderance of the evidence. So, first, legal defense, duress. Okay, what is duress? Well, the textbook defines duress as a condition in which an individual is forced by the wrongful act of another to commit a criminal act. So when you think of the word duress, I want you to think a pressure jam situation. There's a lot of pressure that momentarily or for a period of time potentially almost robs the defendant of free will. How does this work? Well, imagine that you have somebody pointing a gun to uh, a person, right? Let's say a criminal or somebody who doesn't care about other people is pointing a gun at, uh, let's say, Alfred is pointing a gun at Mary, telling Mary that if she doesn't steal uh, a piece of jewelry from the box, he will kill her. If Mary steals the piece of jewelry, she is guilty of larceny, right? Larceny is the intent to steal something from somebody else, roughly speaking. She did mean to steal it. She did steal it, and she didn't want to do it when she did it. The mens rea and the actus reus are at the same time, and the act of the loss of that jewelry item was caused by Mary's actions. But we instinctively know that even though she did mean to do it at the time she did it, she didn't want to do it. The only reason she wanted to do it is because there's a gun being pointed at her. That situation is referred to as duress. So duress is when the threat of force is being used against a human being to commit a crime. Now, many of, or some of these states, some states allow for duress to also apply in situations where the threat is being caused or is being done to a third person. So imagine if somebody's parents have their child kidnapped, and the person who, or the people who kidnapped the child from the parents, tell the parents that they will kill the child unless they commit a crime. Some, but not all states, would also extend duress to that situation. However, duress will never, ever, ever be used to justify a person killing somebody else or raping somebody else. Under no circumstances can you use duress for those crimes. And there's all sorts of explanations as to why that I'm not going to get into. But those two, you're not going to be able, in other words, if somebody has a gun pointed to your head telling you, hey, listen, if you don't kill the person in front of you, I'm going to kill you. If you go ahead and kill the person in front of you, you cannot use duress as a defense. You're going to be found guilty. So that's duress. That's the first defense, affirmative defense that we're going to go over, or that we're going over. The second one that I want to go over is necessity. Necessity. Now, necessity is a bit tricky. Sometimes people confuse duress with necessity. How does the textbook define necessity? Necessity is a legal defense in which a criminal act, though criminal under other a legal defense in which an act, though criminal in other circumstances, may not be considered criminal because of the compelling force of the circumstance. Okay. This is tricky. So when you're talking about necessity, I want you to think of environmental factors. We're not really talking about a human being threatening you. We're talking about pretty much like you're in a situation where if you don't commit a crime, you might die. Not because you're going to get killed by somebody, but for factors like starvation or drowning. So let me give you a couple of examples so that we can kind of illustrate the point. Okay. If you are the captain of a ship and you're out in the middle of the ocean and out of nowhere your ship begins to sink, you will be allowed to throw property overboard. Called vandalism, right? Vandalism is the intentional destruction of property. You will be allowed to throw the property overboard into the ocean as a means of preventing the ship from sinking. Why? Because if the ship sinks, everybody in the ship will probably die. And so you are in a situation that it is unavoidable. If you don't commit the crime, it is unavoidable for life to be lost. Life will be lost if you don't commit the crime. There's no way around it. Okay? The environment that you're in, has put you in that situation. And so even though the captain of the ship did instruct and did commit vandalism along with all the crewmen who threw the cargo over the ship out into the ocean, the defense of necessity will prevent them from being found or from being punished criminally, even though they did commit the crime. Now, of course, that doesn't mean that the captain of the ship or the owner of the ship won't be required to financially compensate or pay back the owners of the cargo for the loss of cargo. That's a whole different case. That's civil, right? And that might be contract issues and whatnot. But it won't be considered a crime, right? It won't be considered a crime. Another example of necessity is, imagine that you are in the middle of a hurricane, right? There's a horrible hurricane, you've lost your house, and you're trying to find shelter to protect you from all sorts of debris that's hitting you. And you break into a house that was, you break into a house, maybe uninhabited, to find shelter. Well, that is breaking and entering, right? That is trespass, that is a crime. However, because of the environmental circumstances around you, your actions will be excused, meaning you will not be found to have committed the crime, or you will be excused even though you did commit the crime. You will not be found guilty because of this legal defense necessity. All right. Now, a third defense, infancy. Okay. Infancy is a very interesting defense, right? The textbook defines infancy as, where is it? Well, they don't put it in here as a defense. Well, that's weird. But infancy is, simply speaking, a legal defense that takes place when the person who committed the crime does not have the legal competence because of their age, meaning they don't have the capacity to understand the consequences of their actions because of their age. That's infancy. That's the legal defense called infancy. It comes from the British under common law. Now, historically, children under the age of 6, regardless of what they did, could not be found guilty of committing a crime because they lack the mental capacity to understand the consequences of their actions. So even if they meant to do it, even if they physically did the crime, even if there are all the other attendant circumstances and the causation issue are all met for the crime to have existed, because of how young the child was when they did commit the crime, they will not be found guilty of that crime. So 6 and under would never be found guilty of committing crimes. Now, from 7 to 14, historically, from 7 to 14, a child was presumed to not be able to commit a crime, but the state could offer evidence suggesting that they knew what they were doing, that they understood the consequences of their actions. So if you're from 7 to 14, the presumption is that you don't know what you're doing, but the state may offer evidence showing that you did know what you were doing, that you understood what the consequences of your actions, either because you were mature or because you were of age, you were intelligent and high IQ. Whatever the facts may be, the state can overcome this presumption, but the state has to do so. Otherwise, not guilty, again, because of infancy. And then, of course, from 15 and up, the infancy defense really doesn't exist. what you'll see from 15 to 17, even to this day, is that perhaps in certain circumstances, the punishment will be smaller. Right? We may not punish the individual as severely as somebody who is significantly older because perhaps a 16-year-old doesn't understand as well. They do understand, but not as well as a 30-year-old. All right. And so that is the infancy defense. Now, the fourth legal defense is insanity. Now, insanity is a term that nowadays has really lost a lot of favor. It's not a term that we like using. It's very condescending. It has negative connotations. Insanity, though, as a defense, is a catch-all phrase that essentially means that the defendant, at the time they committed the crime, or maybe on a permanent basis, doesn't really, or has a state of mind that eliminates their responsibility, or was in a state of mind that eliminates their responsibility for their actions because they are mentally unhealthy. Either they are mentally challenged, or they suffer from schizophrenia, or at the time they committed the crime, there was a severe mental illness that was affecting them. We call that temporary insanity. Now, insanity really has a bad rap for many different reasons. No longer is it acceptable for many people because of the negative connotation that the term has. It's really a bit of an insult. But aside from that, the other problem with the insanity defense that many people have is that they think that everybody uses it and everybody gets away with it. In reality, the insanity defense is used in less than 1% of all felony cases. It's used by the defense very rarely, and it's extremely, extremely rare for the judge to grant the defense or for the jury to accept the defense. Okay, so what are examples of insanity? Schizophrenia, somebody who suffers from schizophrenia, meaning that they hear voices in their head. It's a very real mental health illness. If you suffer from schizophrenia, perhaps you will be able to use the insanity defense. If you are somebody who is mentally challenged, right? Somebody that suffers from Down syndrome, for example. Well, obviously these people don't fully comprehend what they're doing. They may have wanted to do what they did, or they may have had the mens rea, but they don't have a full comprehension of the consequences of their actions. So perhaps or very likely they'll be able to use the insanity defense in many circumstances. All right. And that's basically the insanity defense. The textbook goes into a lot more detail regarding the insanity defense. I don't want to get into it. So that is the fourth defense the textbook mentions. I'm confused. Oh, there we go. I was waiting for another one. The fifth defense that the textbook mentions is what is called automatism. Automatism. What is this? This is when the defendants offer evidence that at the time they committed the crime, they were unconscious or semi-conscious. So automatism can really be classified as a physical problem. Examples include an epileptic seizure, a concussion, an unexplained blackout, something that caused the defendant to lose control of their body at the time they committed a criminal act. Now, many people ask themselves, how can this work? Well, I know of people who suffer from, they sleepwalk. Okay. And if there's somebody who, for example, sleepwalks, they might be able, they no longer have a complete control over their body. So perhaps while they were sleepwalking, they went into somebody else's house and stole, a wallet. The defense has the obligation of proving this affirmative defense. But if it did happen, the defendant shouldn't be punished because they didn't have full control over their body. Okay, they didn't really have the actus reus. If you have an epileptic seizure, or let's say you have an epileptic seizure while you're pointing a gun at somebody, or while you have a gun out, maybe you're hunting with somebody and you have a seizure that causes you to kill somebody. Well, we're going to use the automatism defense because you didn't really have full control over your body. The defense is going to be allowed to bring in evidence that that the defendant was unconscious or semi-conscious when they committed the criminal act. So that is the fifth affirmative defense. The sixth affirmative defense is entrapment. Okay. Now, entrapment is a bit tricky. The way that this legal defense or this affirmative defense works, according to the textbook, I'll give you the definition first, is that it's when the defendant was induced or convinced by a government agent to commit a crime that the defendant would not have wanted to commit without that inducement, without that act of convincing. So in other words, the cops went out of their way to try to convince you to commit a crime that you otherwise wouldn't have committed. So for example, if a police officer approaches you and convinces you to open up a meth lab when you had zero intent to open up a meth lab, and then they arrest you for operating for drug trafficking, right? You were entrapped. A police officer, a law enforcement official, tried to manipulate you, convince you to committing this crime when otherwise you would not have committed it. Now, entrapment is very, very strange because sometimes people say, well, what about undercover cops? Undercover cops are not the same thing. If you're an undercover police officer, you are giving a potential criminal the opportunity to continue doing a crime they already regularly do. So, for example, if an undercover cop shows up to a bar and asks a person who is suspected of selling drugs to sell them a bag of weed, well, that's not entrapment because that person is in the drug trafficking business and the cop is simply giving them another opportunity to continue committing the same crime they regularly commit. So it's not entrapment in that situation. For entrapment to exist, the defense has to prove by a preponderance of the evidence, remember, two elements. The first one is that a government agent induced or convinced the defendant to commit the crime. And secondly, that the defendant will not have committed the crime if the government agent had not tried to convince them to do so. So it's a bit tricky to prove. But that is the sixth affirmative defense. Okay. Now, the next three defenses, the next three affirmative defenses are all interrelated. Okay. Number 7, self-defense. A person may use reasonable force to defend themselves from physical aggression. That's basically the concept of self-defense. So let's see if the book gives a definition. I have a feeling they don't give a definition here. Yeah, they don't have a definition. But the way that the book mentions it is that a person is allowed to use force to counter the actions of another person under the following circumstances. There are 4 circumstances that must be met in order for self-defense to exist. These are the 4 elements to self-defense. Number 1, the individual has an honest and reasonable belief that he or she is, number 2, facing an unlawful threat of immediate death or serious bodily injury. Okay. Number 3, by an aggressor, okay, meaning somebody who is initiating these actions aggressively, not because that person is responding in self-defense. And 4, the force used was reasonable under the circumstance. So again, the 4 elements for self-defense. The person using self-defense has an honest and reasonable belief that he or she is, number two, facing an unlawful threat of immediate death or serious bodily injury, number three, by an aggressor, and number four, the force used was reasonable under the circumstances. Now, of course, what is reasonable under the circumstances? That varies depending on the situation. If two guys are simply just punching each other, that probably doesn't justify one of them pulling a gun and shooting somebody else. But if an MMA fighter, right, a mixed martial artist, or if a UFC fighter is trying to punch a very small woman with no experience in martial arts, in that situation, that woman is going to be allowed to use a gun and shoot the MMA, because the amount of harm that person could cause the woman is much larger. See how it's different? So the circumstances dictate how much force the defendant that is raising self-defense may use in self-defense. Okay, so that's the seventh legal defense. That's the seventh affirmative defense. The eighth affirmative defense is defense of others. So it's the exact same thing as self-defense, except that instead of you using the defense for yourself, you are using physical force to defend another person. And all the criteria, the four elements that had to be met for self-defense to take place, all have to be met, except that instead of it being done for yourself, you're doing it to defend a third person, another person. Okay? And number 10, defense of property. Okay? Now, defense of property is very tricky and very controversial depending on the state that you live in. You are allowed, in most states, in almost all states, the ability to defend your property. So, for example, a thief is trying to break into your car, you're allowed to use physical force. You're allowed to batter the person. Why? Because they're trying to harm your car, they're trying to break your car, they're trying to steal from your property. Okay? Now, in almost all cases, you will not be allowed to use deadly force to defend property. Somebody's trying to break into your car, for the most part, you're not going to be allowed to pull out a gun and shoot them. Okay? Now, the exception to that is what's known as the Castle Doctrine. The Castle Doctrine, also known as stand your ground laws, do not exist in every state. In Florida, we have them, and they're some of the most powerful laws, or stand your ground laws, and not the most powerful one or the most strong one in the United States. And what they mean is that if a person is trying to break into your house, historically your castle, you're allowed to use deadly force to stop that person, as long as they're not trying to flee. For the most part, you're allowed to do it. Okay. Not necessarily that I recommend it, and this law does change frequently in different parts of the United States. So I don't. It's not necessarily one of the most advisable laws for you to do. But if you are in a stand your ground state, you may use potentially, depending on the circumstances, deadly force to protect your home. Only your home. Your home. So that is the 10th affirmative defense. The 11th affirmative defense, and the last affirmative defense that we're going to talk about today, is intoxication. Okay. Now, what is intoxication? Okay. Intoxication is the condition that exists when a person consumes alcohol or other drugs to the extent that his or her mental or physical abilities are significantly affected. Now, the thing about intoxication is that it is a limited affirmative defense. It's not unlimited, it's very limited. So, for example, if you are drunk while you killed somebody and you never planned it out, the law allows you to use intoxication as a defense to the mens rea of intentional. The idea being that if you're drunk, you don't really know what you want to do overall. So the state will not be able to charge you with first or second degree, as long as you didn't plan to get drunk beforehand, at which point they will. Plan to get drunk beforehand to kill the person, at which point then you planned it and meant to do it before you got drunk. But as long as the action took place spur of the moment, when you were drunk, your intoxication is going to be allowed to the defendant's going to be allowed to use that defense to eliminate the mental state of intentionality. However, it will still be a third-degree murder, a reckless killing. Okay, because intoxication does not stop recklessness. Same way that if you get behind the wheel while drunk and you kill somebody, intoxication will allow you to not have the criminal charge of that you meant to kill a person or that you plan to kill a person, so that intoxication will protect you from a first or second degree charge. But it will not protect you from a DUI, manslaughter, or from a third degree murder, or from a vehicular homicide. Every state labels them differently. So intoxication is a partial defense. It's a limited defense. It's not a complete defense. It doesn't necessarily eliminate the fact that you committed a crime. It just means that you may not have committed as serious a crime as otherwise would have happened had you been sober. And that's how intoxication works. And with that, we finish today's lecture. See you guys next week. Stay safe, everybody. Bye.